Chapter 4, Civil Liberties and Public Policy. I am starting on page 87. Civil liberties are constitutional and other legal protections of individuals against government action. American civil liberties are set down in the Bill of Rights, the first 10 amendments to the Constitution. At first glance, many questions about civil liberties issues may seem straightforward. For example, the Bill of Rights guarantee of a free press appears to mean that Americans can write what they choose. In the real world of American law, however, these issues are subtle and complex. Disputes about civil liberties often end up in court. The Supreme Court of the U.S. is the final interpreter of the content and scope of our liberties. This ultimate power to interpret the Constitution accounts for the ferocious debate over presidential appointments to the Supreme Court. Throughout this chapter, you will find special features titled You're the Judge. Each features describe an actual case heard by the Supreme Court and ask you to decide the case and then compare your decision with that of the court. To understand the specifics of American civil liberties, we must first understand the Bill of Rights. Okay, so civil liberties are your protections against abuse of government. Your freedom of religion, press, your right to against self-incrimination, Fifth Amendment, plead the Fifth. Civil rights is your right to be treated equally in front of the law. And that's the 14th Amendment. That's the next chapter. Okay. By 1787, all state constitutions had Bill of Rights, some of which survive intact to this day. Although the new U.S. Constitution had no Bill of Rights, the state ratifying conventions made the passage of amendments providing rights a condition of ratification. So think back to the beginning of the year. The anti-federalists, the critics, were weary that there was no Bill of Rights included. Because they thought, and some even were conspiracy theorists about this, that was because they were going to take the rights. But the reason, the justification, according to Madison, that they did not need a Bill of Rights for the national government because the national government was restricted to only enumerated powers, enumerated, express, delegated, to only the powers of Article 1, Section 8. So since they were a restricted model, you didn't need to have the protections, but the states, which did the bulk of the government at that time, all had Bill of Rights, and they were at the beginning of their constitutions. Obviously, though, the first Congress passed the Bill of Rights in 1789 and sent it to the states for ratification. In 1791, these amendments became part of the Constitution. There were 12 amendments, of which 10 were ratified. There was an 11th one ratified, is the 27th Amendment. The last amendment of the 27 amendments is one of the original from the Bill of Rights. And then there was another one, which I cannot remember, but please feel free to Google, that did not get ratified. The Bill of Rights ensures Americans' basic liberties, such as freedom of speech and religion and protection against arbitrary searches and being held for long periods without trial. When the Bill of Rights was ratified, British abuses of the colonists' civil liberties were still a fresh and bitter memory. Colonial officials had jailed newspaper editors, arrested citizens without cause, and detained people and forced them to confess at gunpoint or worse. They wouldn't have been citizens back then, they would have been subjects. But anyway, thus the first 10 amendments enjoyed great popular support. Political scientists have discovered that Americans are devotees of rights in theory. Their support often wavers when it comes time to put those rights into practice, however. For example, Americans in general believe in freedom of speech, but many citizens oppose letting the Ku Klux Klan speak in their neighborhood or allowing public schools to teach about atheism or homosexuality. In addition, Americans seem willing to trade civil liberties for security when they feel that the nation is threatened, as in the case of terrorism back in September 11th. Because few rights are absolute, we cannot avoid the difficult questions of how to balance civil liberties with other individual and societal values. Another one I would add that we tend to believe in civil protections, but then civil liberties, but then we don't like criminals or people who we think are criminals or people accused of crimes have rights too. And a lot of Americans often have a difficulty with that concept. Take another look at the First Amendment. Note the first words. Congress shall make no law. The founders wrote the Bill of Rights to restrict the powers of the new national government. What happens, however, if a state law that violates one of the rights protected by the federal Bill of Rights and the state's constitution does not prohibit this abridgment of freedom? In 1833, the answer to that question was nothing. The Bill of Rights, said the Supreme Court in Barron v. Baltimore, restrained only the national government, not states or cities. Okay, this is something that's a big deal. Remember, the federal Constitution is for, and the federal Bill of Rights, which is part of the federal Constitution, is about restricting the federal government, the national government only, not the states. So you could not use the Bill of Rights to restrict or to strike down state law when it comes to the Bill of Rights. This changes, and that's what we're going to go into here. And it's very important that you understand it. Ask questions if you don't. An opening toward a different answer was provided by the 14th Amendment, one of the three Civil War amendments, which was ratified in 1868. The Civil War amendments is the 13th, ending slavery, the 14th Amendment, which is considered the most important amendment of the Constitution, or second only to the First Amendment. 14th Amendment, which we'll cover in this chapter, next chapter, and then the 15th Amendment, which was cannot deny a man the right to vote based on race. We found other ways, but it was the voting one. Okay, so we're going to deal with the 14th Amendment. No state shall make or enforce any law which shall abridge the privileges or immunity of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protections of the law. So this is bringing the states in here. Nonetheless, in the slaughterhouse cases, the Supreme Court gave a narrow interpretation of the 14th Amendment Privileges or Immunities Clause, concluding that it applied only to national citizenship and not state citizenship, and thus did little to protect citizens against state actions. If you go into law, or if you go into more detail about the Bill of Rights, you'll learn more about the slaughterhouse cases as being part of our history. I'm not going to test on that. There's a lot to it, and we're going to go with what the current is, not what the history is. And so here's the current. In 1924, in Gitlow v. New York, however, the court relied on the 14th Amendment to rule that a state government must respect some First Amendment rights. Specifically, the court said that freedoms of speech and press were fundamental personal rights and liberties protected by the Due Process Clause of the 14th Amendment from impairment by the states. In effect, the court interpreted the 14th Amendment to say that states could not abridge the freedoms of expression protected by the First Amendment. So per the 14th Amendment, the First Amendment applies to state law too, or state action. This decision began the development of the incorporation doctrine, to incorporate, the legal concept under which the Supreme Court has nationalized the Bill of Rights by making most of its provisions applicable to the states through the 14th Amendment. In Gitlow, the Supreme Court held only parts of the First Amendment to be binding on the states. Gradually, and especially during the 1960s, the court applied most of the Bill of Rights to the states. Many of the decisions that nationalized provisions of the Bill of Rights were controversial. Nevertheless, today the Bill of Rights guarantees individual freedoms against infringement by state and local governments, as well as by the national government. Only the Third and Seventh Amendments, the grand jury requirement of the Fifth Amendment, and the prohibition against excessive fines and bail in the Eighth Amendment have not been applied specifically to the states. So if you take a look at the table, all we're doing is we're incorporating the Bill of Rights, the U.S. Federal Bill of Rights, to state law and state action. via the vehicle of being the 14th Amendment. So because the 14th Amendment applies it to states, case by case, it was selective incorporation. It was case by case, not all of it. The Supreme Court never ruled all the Bill of Rights must apply all to the states. They did it selectively, case by state case, selective incorporation. So we have speech through the Gitlow case, press through the Near case, assembly, a bunch on religion. Well, we have free exercise, establishment, association. Then if you go up down to here, let's find the first. Well, I want to find the second. The Second Amendment, I want you to notice 2010. So Second Amendment did not get incorporated, and it's very specific on what it's incorporating at this time till 2010, McDonald v. Chicago. Third is not incorporated because it's never been a lawsuit. Fifth, this part is not incorporated. There is one that has been very recent since the book was written, that I'll have to look up. But so case by case, they will apply part of the U.S. Constitution amendments, Bill of Rights, to the state in a state action or a state law. Okay. So freedom of religion. The First Amendment contains two elements regarding religion and government. These elements are commonly referred to as the Establishment Clause and the Free Exercise Clause. The Establishment Clause states that Congress shall make no law respecting an establishment of religion. The Free Exercise Clause prohibits the abridgment of citizens' freedom to worship or not to worship as they please. By the way, that doesn't mean when this Constitution was written, the states were in a different place when it came to establishment and free exercise. Even though Congress couldn't make these laws, there were states that made these laws. Always keep that in mind for any of this. The government's practice of providing chaplains on military bases is one example of this conflict. Some accuse the government of establishing religion in order to ensure that members of the armed forces can freely practice their religion. Usually, however, Establishment Clause and Free Exercise Clause raise different kinds of conflict. Religious issues and controversies have assumed importance in political debate in recent years. So it is not surprising that interpretations of the Constitution are intertwined with partisan politics. Establishment Clause. We will now go over the religion in another one because I'm going to skip to the defendant's rights.